And we are now recording and attendees are coming in. Hello, everybody. We're up to 17 attendees. I think we're going to get close to 90 attendees. It's going to be amazing. So as soon as we have all the attendees, we'll get started. For now, everybody's looking out the window, seeing that there's actually some sunshine today, which is a nice change from yesterday. And for those of you who live in the mountains, I hear some people actually had
a couple inches of snow overnight.
Yeah, snow. And like I talked to one person who had a foot of snow. This was in upstate New Hampshire. Now I can't imagine, like, you know, this was May 10th and you wake up and you have 10 inches or 12 inches of snow. That's crazy. Yeah. Not a great way to celebrate Mother's Day. Yeah. So. All right, we still have lots of attendees coming in. We're just going to give it another 30 seconds or so to have all the attendees sign in, and then Kathy, if you want to start, that would be great.
You ready?
All right, Kathy, yeah, you want to start?
Great.
Yeah.
So welcome, everyone. I'm Kathy Davis, the Executive Vice President of the Lake Champlain Chamber, and I appreciate all of our attendees joining us for what should be a really interesting hour. And I want to specifically thank the DRM team for taking the time to share their knowledge with all of us. And with that, I will turn it over to John Maitland with DRM. Thank you.
Oh, hi, everybody. I'm John Maitland. I'm a labor and employment attorney at Downs Racklin Martin. I want to start off by thanking Kathy Davis and the Lake Champlain Regional Chamber of Commerce. Thank you very much for hosting us, and so glad we could do this for you all and for your members. It's such a timely topic on sort of all the strategies with respect to returning to work. So I'd like to introduce our team. We've got a great team. We've got the entire Downs Racklin Martin Labor and Employment team on. So our chair is Beth Radigan. So, and then Tim Copeland from our Brattleboro office. David Harlow, who's also in our Brattleboro office. And Andrea Wright, who's also in our Brattleboro office. April Tuck, who's in our Burlington office. Ben Travers, who's in our Burlington office. And Amy Braun, who is in our Lebanon, New Hampshire office. Also want to thank Monique Trono, who is one of our administrative assistants, who's done an incredible amount of work of helping put all of this together. So a few preliminaries before we get started. Our format today is going to be 4 different topics. And each topic will have about 10 minutes presentation, and then we'll have a Q&A afterwards. So for the Q&A, please use the Q&A that's at the bottom of your screen. There's also a chat feature. We won't be monitoring the chat feature as much, so we strongly encourage you to use the Q&A format so we can keep track of all the questions. Also want to let you know we're recording the session. And for those of you who are listening on the recording, please note that this has been recorded on May 12th, 2020. And so, you know, this area is a constantly changing area. So recognize that, you know, if you're listening to it after the 12th, some of it may be out of date. And that's just a good reminder for everybody, is that these rules are constantly changing. So what we're providing you today is guidance. Also have to give you a brief disclaimer. It's, you know, we're not providing specific legal advice. And the reason is because each situation is different industries, different organizations. So, yeah, you know, please make sure that, you know, that this is guidance, and please make sure to check the updates. So with that, let me get started. I will share my screen, and then we can get started with our PowerPoint. So, successful strategies to return to work. Let me give you the overall framework very briefly. The framework is that in Vermont, we still have this stay-at-home order through Friday. The governor has hinted pretty strongly that the stay-at-home order is going to go away, and that there'll be some relaxing of that order. Exactly what that looks like, We don't know, but stay tuned. We will very likely hear either, tomorrow, Thursday, or Friday, most likely Friday, what that's going to mean. We've given you 2 links, and for those of you, don't worry, you will get these links because we will have the PowerPoint and send out the PowerPoint so that you can get all of the links. Sunday, we had 0 cases in Vermont, so clearly the governor's very slow restarting Vermont phase seems to be working, and so we can expect to continue having a slow opening up of the spigot, as Governor Scott likes to say. So with that, let me get started on our first topic, is safe workspaces, and Ben Travers is going to present on that. So take it away, Ben.
Hi, John. Yeah, I'm Ben Travers, an attorney in our Burlington office, and allow me to also extend my thanks to the Lake Chamber and Kathy Davis for inviting us here. I've been very involved with the Chamber's Excellent Leadership Champlain program over the years, and it's really great to be able to take on this role as well. We could spend an entire hour just on this portion of turning to the workplace safely, but I'm going to try to briefly get through it all and be considerate of your all's time. First and foremost, as John mentioned, the guidance is changing almost daily now. And the first thing that any employer can do is to make sure that you're staying updated as to what that guidance is. There's some links here to some federal websites that have provided good guidance. The Centers for Disease Control, CDC, has put out some guidance for businesses and employers. OSHA has put out guidance on preparing workplaces. I should also mention that the Chamber has put out great resources to employees, and given that we're here, I should also note that DRM at drm.com also has a COVID-19 resource page for you all. In Vermont, VOSHA, the Vermont entity of OSHA, has put out guidance to employers. The Vermont Department of Health, of course, has also been keeping its website up to date pretty well. I think perhaps, however, the most important website for different sectors will be the information that's being put out by the Vermont Agency of Commerce and Community Development, or ACCD. This is where you're going to get sector-specific guidance on whatever business you're in. The most recent guidance that came out is with respect to outdoor recreation businesses, where there's additional guidance that's coming out with respect to retail coming back online. Previously, you saw guidance with respect to manufacturing, construction industries, the golf industry. So we're not going to go through each of those individual industries. What we're going to cover are those guidelines that are applicable to all businesses. However, just know, depending on what business you're in, there very well may be different parameters specific to you that would be available on the ACCD page. So what are the steps that all employers are expected to follow here? Well, first steps is, if you haven't done it already, the state has made clear that all employers should be requiring all employees to conduct a VOSHA training program put out by the VOSHA agency. Again, this is for all employees, including those who are already working. They must complete this online training, and employers must document that employees have completed this training on mandatory health and safety requirements. There is an exception for healthcare workers, first responders, and others who are trained in infection control or personal protection. But beyond that exception, all employees are expected to complete this training, which is available online at the VOSHA website. And at the end of the training, there's instructions as to how employees can document their completion of it. Next slide, John. I'm not seeing the next slide yet on my page, but I will keep going on my end. There we go. Other first steps are, beyond having employees undergo the VOSHA training, employers are also expected to develop a written health and safety plan. The ACCD webpage has put together some samples for certain industries, but for most industries, there's a template that employers can complete as to this health and safety plan. In that template, the first thing that you see there is instructions to employers that they should determine who's going to plan for re-entry. So, for example, you could consider creating a committee of different representatives who will plan for this, including folks from your human resources department, facility staff. If your building has security, perhaps you'll consider having representatives from your management or employees. Or if you use third parties for facilities or security, identifying those individuals who work for you who will be liaising with those groups. There's also a requirement, and it's outlined in the template plan here, that employers are supposed to designate on-site health and safety officers for each location shift, given the authority to implement the health and safety plan. Health and safety plan requires that employers adopt a phased approach to reopening, assessing the risk exposure that different employees in different positions will have, and to update their physical and administrative safety guidelines. In updating these physical and administrative safety guidelines, the state has put together this hierarchy that is shown in this pyramid that you'll see in their template plan, from the most effective controls that employers can put into place to the least effective. And of course, the most effective things that employers can do is, to the extent they can, is to eliminate tasks that would potentially give rise to exposure. And John, if you go to the next slide here. Starting on the elimination and substitution of different tasks, the state has made clear to all employers that if you're able to use remote work, that employers must use remote work whenever possible. Continuing on with tasks that employers may eliminate, employees may not be at the workplace if they're sick or symptomatic. And in fact, employers are required to put signs up. You may have seen them at some stores that you're already going to. Signs posted at all entrances saying that employees may not come in if sick or symptomatic. If an employee has come into contact with a person who's diagnosed with COVID-19, they're required to stay home for 14 days. Employers are instructed to limit face-to-face meetings and also to limit staff travel between multiple sites. And of course, the guidance is still out there with respect to out-of-state workers, that if these folks are unless they are coming into the state for essential work, they're supposed to quarantine for 14 days. Then the plan talks about different administrative engineering controls. So if folks have to come into the office, they can't remote work, they are not sick or symptomatic, and they're there. This is guidance that the state has put out. Consider staggering work shifts, break times, et cetera, and expanding your hours to limit the number of people who are in the office at one time. My colleague Beth Radigan will talk about this momentarily. But employers are now instructed to engage in pre-screening and a health survey to verify each employee has no symptoms before each shift, which would include taking employees' temperatures before they come into the workplace. Employers are supposed to observe strict social distancing of 6 feet. The use of shared workspaces is discouraged to the maximum extent practicable. And employers should limit the occupancy of common areas to allow for this social distancing of 6 feet. So cafeterias, lobbies, you should limit the occupancy of those areas. Continuing on with other requirements and administrative engineering controls that are out there. Next slide, John, if you haven't. Yep. All common spaces and equipment must be cleaned regularly and when possible prior to transfer. So that would extend to, for example, vehicles. If you have 2 different employees using the same vehicle throughout a workday, employers are required to clean that vehicle prior to the transfer from one employee to the next. Hand washing, hand sanitation is required frequently, including before the entry and exit to the workplace. And to the extent possible, if you have vendors or customers or others coming into your work site, employers are said to provide access to those hand washing or hand sanitizing stations. When indoors, employers should be opening doors and windows. Thankfully, it's gotten a little warmer outside, so that's doable to the end of encouraging airflow. And again, on vehicles, no more than 2 people can be in a vehicle at one time. And finally, I think perhaps one of the ways in which the place will look and feel most different to us when we return is requirements with respect to employees using personal protective equipment. So once all these administrative engineering controls have been put into place, if you still have folks coming into the workplace, employees are required to wear face coverings when they're in the presence of others. In the retail setting for retail cashiers, the plexiglass or some other translucent shield is acceptable in lieu of a mask. And then you may have seen recently in the context of retail businesses restarting, there's guidance that businesses may require, but at this point in time are not required to require, that customers or clients wear masks when they come into the place of work. Stay tuned to that, though. The governor has said that the legislature were to pass some legislation requiring the use of masks in these areas, that he would consider signing that. But for now, businesses may require that. That's the guidance that's been put out so far. Again, stay tuned. The most important thing here, in addition to staying updated, is obviously the practices that you put into place are only going to be as good as your employees are aware of them. So it's important that you clearly communicate these practices to your employees prior to their return to work. Once employees have returned, continue to regularly communicate with them and keep them updated as to the changes. As I mentioned previously, use posters and other reminders throughout the workplace. And employees are going to have questions and concerns. So in whatever plan you put together, make sure that there's a clear channel for those questions and concerns to be voiced. Thanks, John.
All right, great. Ben, thank you very much. Amy has been monitoring our questions. Is there a question or two that we should bring up right now, Amy?
Sure. One question that came in is that in regards to the health and safety officer being on site, what's the expectation if there's only one employee who's coming into the office?
Yeah, that's a good question. So they haven't put out any guidance about an exception to the health and safety officer requirement when you only have one or two employees coming into work. So I think that technically speaking, the expectation is that that one individual who you have coming into the workplace is your health and safety officer, right? So to the extent you have requirements to clean after you use a common area, as an example, to open doors or windows, to have customers hand washing and hand sanitizing when they come into the workplace, it's going to be that one employee who will be expected to fulfill those requirements. But for most places that have more than one or two people coming in, it will be that one health and safety officer on site. Every location, every shift will be expected to see compliance among all employees.
Okay, great. Amy, I think we have time for one more question if there's another one.
Sure. I think we've seen this one come up before too. Are essential employers required to have a written health and safety plan? I think this goes to, do all these requirements apply to the businesses that are just reopening, or everything that's continued to stay open during this time?
Yeah, so these requirements, the requirements through, are applicable to all businesses. So that includes essential businesses that have been opened throughout this period of time. Now, obviously, there's going to be some businesses that aren't always able to maintain constantly 6 feet social distancing, as an example. But nonetheless, to the extent practicable, even those employers are expected to do it and should have this written health and safety plan on record. The OSHA training as well, unless you're unless it's for healthcare employees or for first responders, all employees are expected to conduct that OSHA training. And I've had this question from healthcare employers, does that exception apply to all employees of healthcare employers? And the answer to that is perhaps no. The exception extends to healthcare employees, or those who have undergone training on personal protection and infection control. You can imagine healthcare employers might have employees well beyond that who perhaps have not undergone that training yet. And for those individuals, the OSHA training would be required.
Okay, great. Ben and Amy, thank you very much. And I just want to let all of our attendees know, at times we're experiencing a little bit of a lag, so both on the PowerPoint slides and in the, so bear with us and we'll do our best to work our way through that. So our next presentation is on health screenings. And Beth is going to lead us through that. So here should be your screen. So Beth, please take it away.
Good morning, everyone. So in early May, the EEOC came out with new guidance on monitoring and health screening of folks at work work, and particularly with an emphasis on what the ADA will allow folks to do. The big news, of course, is that employers can now require certain testing and screenings at work. Previously, this, of course, was not required. You could not, as a part of your normal workforce practices, ask people about their medical history and their current medical state, because that would be a violation of the ADA. But the EEOC has said that this pandemic, the COVID pandemic, meets the definition of a direct threat. And some of you may have heard this term before, but under the ADA, if something causes a direct threat to the individual or to others at work, then then employers have different ability to act or take actions based on that direct threat. So testing and monitoring can happen now. And in fact, in Vermont, certain kinds of testing is required, such as temperature checks. But the important thing to remember is that any kind of testing or inquiry should be job related and consistent with business necessity. So there should be no broader than necessary. And throughout all of this testing and monitoring, confidentiality is key. You have a strict confidentiality obligation under the ADA, and you must maintain any records that you compile in a confidential manner, and the other information that is medically related must be maintained in a confidential manner. So the EEOC has said that temperature checks they're expressly permitted by the EEOC in its guidance, and in a executive order that happened a couple of weeks ago in Vermont, the temperature checks are actually required. Other types of tests were not addressed by the EEOC, but presuming it is okay under the guidance that the EEOC has provided. So employers, if they have the ability to do so, can require employees to undergo the COVID testing as well. Some employers are considering doing antibody testing, and that remains somewhat controversial because there is uncertainty about what that antibody test would reveal. In either case, however, if employers are going to use COVID tests or antibody tests, we strongly recommend that you obtain written consents from your employees, particularly noting that you're not providing any kind of medical advice and that the tests may have false positives or false negatives, and you're not guaranteeing any result. Any kind of monitoring you do, whether it's the temperature check or other types of monitoring, it must be non-discriminatory. And I think this speaks for itself, but sometimes, particularly where we have a situation currently where there are certain high-risk individuals, you may be tempted to say, okay, I'm only going to test everyone over 60. You cannot do that. That would be considered a discriminatory application. So generally our advice is if you're going to monitor, you monitor everyone. You should use clear and uniform standards. So for instance, the CDC has said a fever is anything over 100.4 degrees or 38 degrees centigrade. You should also have properly trained and outfitted personnel. Some folks may be hiring third parties, particularly if it's administering a test other than a temperature test. And you should include, at least consider whether you're going to have vendors and visitors to your business also undergo temperature checks or other kind of screening tools. Keep in mind that if you are doing temperature checks, you may have to pay employees while they're waiting, because presumably you are doing these tests before people start their workday, before they come in the door. And there are certain situations where, depending on the size of your workforce, you could have people lined up waiting. And if you have non-exempt employees, you may have to consider paying, you will have to consider that as part of their paid work time for waiting until test. For inquiries, so health screening inquiries, in addition to just the temperature checks, you can also ask, and you should, it's recommended that you ask your employees about their symptoms. And generally this is being done on a regular basis, like the start of each workday. It can be written or it can be an electronic form. You could also have a survey question that you present orally, but you would want to track the results of that. So you have a checklist, kind of go down and ask each person. but you would want to have a record that you've done that. And it's very important that you keep such record in a confidential manner, not mixed in with personnel files, for instance. So you can ask things like, are you experiencing symptoms of COVID-19? Or have you been in close proximity to someone diagnosed with symptoms? You can invite vulnerable population members to self-identify, and that, you know, would be recommended. You may then have accommodation requirements for vulnerable population. So if someone has asthma, for instance, and is more high risk, may have special needs, like maybe wearing a mask will be difficult for that person. And then you may have an obligation to accommodate that in some way by providing some other method, either a plexiglass screen or something else. So keep in mind that with these health screening inquiries, you may be presented with opportunities and requirements to accommodate. It's okay to ask if any of your employees have been in proximity to others with COVID or COVID symptoms, and then whether that employee has engaged in social distancing when they're outside of work. It is okay to ask that. I would warn you not to ask specifically of your employees, does your spouse have COVID, or does your parent or your child? Stay away from specific family members because that could violate the Genetic Information Act. As I have mentioned a couple of times, on April 17th, the Vermont issued an order where employers must pre-screen or survey employees to verify that they have no symptoms. And this pre-screen requires a temperature check. So all employers are required to take the temperature of all employees. Now, at the same time, OSHA has recognized that the non-contact thermometers are in high demand and very short supply. I, for instance, ordered one over a month ago, still haven't gotten it. So they recognize that employers might not be able to comply right away, but compliance will be met if employers immediately order and use their best efforts to obtain a non-contact thermometer. So what you can do before you have a non-contact thermometer to use at work, you can ask people to take their temperature at work, or before they get to work, I'm sorry. You don't want them working 2 hours and then taking their temperature. You want to have, as part of a survey screen, you could ask them if they've taken their temperature, with the understanding that as soon as you have the necessary equipment, the employers need to be undertaking the temperature check themselves. All businesses, as Ben mentioned, must have a health and safety officer on site to monitor and has the authority to stop any activity that's not, within safety. So if someone is circumventing the survey or circumventing the temperature check, there needs to be someone who can intervene and stop that. There have been some questions about, well, what if we only have 2 people going to the office? Then one of those people going to the office needs to be designated as the health and safety officer. If you have multiple locations, you should have a health and safety officer at every location, so that this is sort of the self-enforcement mechanism that the state has come up with. Another question that a lot of employers have is, well, can I require a fitness for duty when someone has been out, or before I let someone come back after they've been sick? Short answer is yes, you can. Keep in mind that when the stay-at-home order is lifted and more businesses are bringing employees back, if you require a fitness for duty, there could be a delay because a lot of doctors or medical facilities will be inundated with such requests. So it may be fine to accept something that's less than a full fitness for duty type form, but something that's just a quick note to say that someone is either no longer suffering from COVID symptoms or has recuperated, has tested negative, whatever the situation may be. You also may get certifications, and it is okay to require a note if an employee says, I have a underlying health condition and so therefore I can't come to work. It is entirely appropriate to ask for medical certification for that from the employee's healthcare provider. Keep in mind that you may, however, as I mentioned before, have to accommodate if someone has a particular disability. Then under the ADA, you have an obligation as an employer to accommodate that. And it might be by providing plexiglass barriers, for instance, distancing. You may not put up sort of temporary walls in your workspace. There could be other changes that would be needed, such as shift changes and or temporarily reassigning some duties if the particular duties created a particular risk for someone. So you need to be aware of the obligation to accommodate. And then what about people that have mild symptoms? Even if they're not tested, if they have mild symptoms that are consistent with COVID, then they should, the general guidance from the CDC has been they should stay out of work at least 7 days since the symptoms first appeared and at least 3 days since recovery. So that's a guideline. And again, this is information that's changing as the CDC learns more and scientists learn more about this. These will be changing for sure. I would expect when we have a better sense of this. But right now, that's what the guidance is that we have. Gotten a lot of questions from employers about, well, what if someone complains of any kind of symptom? And, this is a judgment call situation, but obviously if someone has a symptom that's unrelated to COVID symptoms, like their leg hurts or their back, they threw their back out, obviously something like that is going to have anything to do with COVID and it's a different circumstance. The difficulty comes in when someone has cold-like symptoms that may or may not be COVID, and that's, again, just a judgment call. It's probably best to err on the side of caution and have people stay out until they're symptom-free.
All right, Beth, thank you very much. Tim, have you seen any questions that we should follow up on?
Yeah, there's one question that is kind of along the lines of where Beth concluded her presentation. What if an employee discloses that they were in contact with someone who tested positive, but it was weeks ago? What is the time frame?
Yeah, if they have been symptom-free for 7 days, or they've actually been if they've never gotten sick at all, then I don't think you need to be worried about it. Obviously, it's not foolproof. Someone can come down with it at any point, but if someone is symptom-free, I think it's okay. If you feel like it's a particularly vulnerable situation and someone says, I was around someone who's tested positive yesterday, you might want to err on the side of caution here and say, okay, I'm going to keep you out for 5 to 7 days to see if you develop any symptoms, and if not, then you can come back at that point.
One other interesting question: can we ask employees to sign off that they have checked their own temperatures each morning instead of the employer taking it for their staff?
You can do that initially, but the new guidance in Vermont says the employer must take the temperature. But the Vermont recognizes that you're not going to necessarily have the ability to do that right away because the equipment may not be available. So one option in the meantime is you have to order the equipment, so you're taking an action to start the process of being able to take the temperature. But in the meantime, you could use alternative methods by asking people to take their temperature and sign off on it. But that's not going to be good forever. And I just want to be perfectly clear with it. People understand employers have to take action to begin the process to be set up to take temperatures of employees and not rely on what employees are saying.
Okay, great. So Beth and Tim, thank you very much. Let me just remind all the attendees that if you have a question, please use the Q&A format down at the bottom of your screen, and we'll do our best to answer all of the questions. So our next presenter is David Harlow, who's going to talk about employee refusals to return to work and what do we do about those. So David, do you want to take it away?
Thank you, John, and good morning, everyone. Even if you do all the things that Beth and Ben outlined to create a safe workplace, you are likely to encounter at least some employees who are reluctant to come back to work, if not refusing to come back to work entirely. And my presentation details some examples of different types of refusals that you might encounter and some of the legal obligations that are triggered by those types of employee refusals. Let me start though with just the general rule that employees do not have an absolute right to refuse to work. In fact, to the contrary, employers are generally permitted to instruct their employees about when to work and when not to work and so forth. And what we're talking about here really are specific exceptions to the general rule that the employer has that authority. So here are some examples, and we'll talk about how each of these examples may lead to some different legal obligations for the employer. The first example is, I have a fever and a persistent dry cough. I don't want to come into work today. As Beth described at the end of her presentation, this one I think is an easy one, because this is not just somebody who has a symptom unrelated to COVID. A fever and a persistent dry cough are in fact the symptoms of COVID-19. And I promise this was not scripted. This is my daughter, Emmy Lou. I'm just gonna put her outside. Sorry about that. Anyway, as I was saying, this first example is kind of an easy one, because the symptoms are symptoms of COVID, and consequently, you don't want this person in the workplace. And in fact, you should not do that. There are certain legal obligations that flow from this type of comment. First off, under the recently enacted FFCRA, Families First Coronavirus Response Act, there's up to 80 hours of paid leave available to employees who have symptoms of COVID and are seeking a medical diagnosis. So that's one possibility. Another possible legal obligation is to provide paid sick leave like you would for any employee in Vermont, courtesy of the Vermont paid sick leave statute. And then finally, and I think this is an important point to elaborate on some of Beth's comments, even if someone can prove to you that it's not COVID and it's allergies or some other innocuous underlying condition that is causing them to have these symptoms, think about the effect that it may have on other coworkers to have somebody coughing in the workplace. And I think it's often prudent to just not allow the person to come back while they're coughing or exhibiting these symptoms, regardless of whether or not it's COVID. And obviously a completely unrelated symptom like a sore foot might be outside of that. The second example is, I don't have childcare. And by itself, not having childcare is not a valid or legally protected reason not to return to work. But if the reason that someone doesn't have childcare is due to COVID-19 related closures, then there are some legal obligations that flow from this refusal. First, there may be entitlement to paid leave under the Emergency Paid Sick Leave Act. And secondly, remember that there's an additional 10 weeks of emergency FMLA leave that applies to childcare closures and resulting absences from work. And finally, even if you're an employer that's not covered by these two federal statutes, for example, employers who have over 500 employees, consider your own employer policies and whether or not, given the circumstances and the difficult situation that this problem presents for your workers, whether or not you want to enact an employer policy that's more employee friendly than the law requires. It's not safe for me to return to work due to my heart condition. And this is probably the excuse that I've received the most questions about, not necessarily a heart condition, but about employee concerns about returning that have to do with an underlying health condition. What an employer's obligations here are going to be depends on several unique factors related to that underlying condition. First of all, if the employee's been directed to self-quarantine by a healthcare provider due to this underlying condition, there may be an entitlement to emergency paid sick leave under the federal law. Setting aside any issues related to COVID-19, if the employee is presenting a medical condition that's been certified by a doctor and requiring them to be absent from work, it may be a straightforward application of FMLA principles if all the requirements are met. So we can't forget about the ordinary blocking and tackling of these types of requests. The basic fundamentals still apply. The same goes for the ADA. Even if the underlying condition isn't a direct connection to COVID-19, keep in mind that any employee concerned about being able to return to work may safely may trigger the accommodation process that Beth described. And as in my first example, this may also have applications for Vermont paid sick leave and for general health and safety in the workplace. I like working from home better now. This is one that we expect to get from a lot of employees. There's some really positive things that have come out of this crisis. One is that I think we've all discovered that it is possible and sometimes even a little bit better to be working from home in certain situations. And under Vermont law, there is an obligation to consider flexible work arrangements, which would include working from home. But more importantly, I think for businesses, this is a good opportunity to decide if there are other ways of getting your goals accomplished that will improve employee morale and help people keep safe during this time, even as we slowly transition back to the workplace. And it may be that allowing people to work from home is simply a better business decision. This is another employee refusal that I've got some questions on, and I think many of you may encounter. I'm just not comfortable coming into work because I'm afraid of getting COVID-19. This by itself, this excuse, is not legally protected. There's no generalized fear of getting a disease that allows an employee to refuse a lawful work order. However, if the employee can point to specific failures of the employer to comply with federal or state guidance on how to maintain a safe workforce, i.e. several of those requirements that Ben described, or failures to comply with some of the screening requirements that Beth described, an employee may be raising a safety concern that would be considered a protected complaint. And under OSHA and VOSHA rules, that would prohibit you from retaliating against that employee. So this particular refusal, if connected to some specific workplace safety concerns, may entitle the employee to some protections. But beyond that, and similar to the last example, I think that this type of concern raises some questions for employers about whether or not it is feasible to allow the employee to work from home or to enact some type of voluntary system for employees returning to work, so long as productivity remains the same, or at least somewhat as good as before the crisis, and employee morale and engagement remains good, then it may be better to not be heavy-handed about this in some instances and allow employees to return to work on a voluntary basis. For those employees who may have a specific need for not coming into work because of a fear of COVID-19, it may be, in specific situations, a good time to consider a voluntary personal leave of absence. Another question that's come up, and this is related to the ADA, and I think it applies to this example, is what about employees that have some type of anxiety-related medical condition that's exacerbated by the COVID-19 crisis? For example, I'm not comfortable coming into work because I have anxiety, and that's causing them to be more fearful than usual of getting COVID-19. For those types of mental health conditions, in addition to these principles, you're also going to have to accommodate that under the ADA, which is the interactive process that Beth described. And finally, it's important to recognize that there have been some changes in the way that unemployment compensation works in Vermont. So for those employees who just are afraid of getting COVID-19 and don't want to come back to work, there are expanded opportunities for them to be eligible for unemployment if that means it's the end of their employment, if they separate voluntarily. And that's a reversal of general unemployment compensation rules, which are that if work is available to employees, they are not eligible for unemployment. You can't quit and then get unemployment. These new changes to that general rule allow for employees to voluntarily separate from employment for certain reasons. The most pertinent reason here would be the bullet point below that says there's a, quote, unreasonable risk of being infected with COVID-19 at work. And so it may be possible under these new rules for an employee to say, I've got concerns about the safety for me returning to work, and quit and still be eligible for unemployment, provided that they can demonstrate some type of unreasonable risk. And the fact of the matter may be that you as an employer are taking all the proper precautions and doing things according to federal and state guidance. But given the tremendous number of unemployment claims have been filed and the employee-friendly nature of the process, we suspect that many employees who quit under these circumstances may end up being eligible for unemployment under these new rules. A couple of other notes just about the unemployment changes. First off, the Vermont state changes require employers to provide notice of the availability of unemployment at the time of separation. For those of you who may have furloughed or separated employees in layoffs, that's a new requirement. Charges for benefits paid may be relieved if employees are rehired following a period of unemployment related to COVID. And finally, as many people have discovered, there's a very generous provision in the CARES Act that provides an additional $600 per week for COVID-related unemployment. That additional $600 is available through July 31st, I believe. So it's a temporary benefit, but one for you to be aware of nonetheless.
All right, David, thank you very much. Andrea, any specific questions that have come up on David's presentation?
Yes, there is a question related to the emergency paid sick leave. The question says, what if someone has already used the 2 weeks of emergency paid sick leave because they were quarantined due to being in contact with someone who has COVID-19, and then they get sick? Does the employer provide another 2 weeks of emergency paid sick leave, or if that employee now has to use their PTO?
No, the emergency paid sick leave is capped at 80 hours. There may be, if the employee gets sick and has already used up the 80 hours of paid sick leave, there may be some additional obligations under ordinary FMLA or Vermont paid sick leave statutes, but it's not emergency paid sick leave.
Okay, Andrea, is there another question out there, or shall we move on?
There's one question related to the Family First Coronavirus Response Act. The question is asking, who does it pay for that? Who pays? Is it paid by the employer, and if there is exceptions to the smaller businesses that are under 50 employees?
There is an exception for businesses that are under 50 employees that can prove that compliance with the statute would create a risk to the ongoing viability of the business. And the Department of Labor has issued some guidance as to what specifically should be recorded by an employer in that situation. But it's very uncertain as to whether and how that exception is going to be applied and interpreted by the DOL.
All right, Andrea, thank you very much. David, with a brief appearance of a special guest, thank you very much. And our next presenter is going to be April Tuck. And April is our labor relations consultant, and she's going to be talking about upping your game, reviewing and using lessons learned from all these remote work arrangements. So April, take it away.
All right, thank you, John. So if you could bring up the first slide, that would be great.
Oh, I'm sorry. I have to push the final button. Now I'm good.
All right, great. I just thought it was a test. That's all right.
Nope, it's me.
So you can see from the first slide here that what we know is that many folks are interested and have been interested for the past 25 years with the opportunity to work remotely. Last week, IBM published the results of a survey they conducted of 25,000 employees. And of those employees surveyed, 75% of them were interested in continuing to work at home in at least a partial capacity. And 40% of the respondents said that they felt strongly that regardless of whether they chose to work remotely or not, they wanted to be able to opt into that. So while we're in the midst of this accidental social experiment, it's really giving us the opportunity to examine what works not only for our employees, but our businesses as well. Okay, thanks, John. So there are 5 major areas with regard to remote work that are currently being explored, although again, there are even more variations. The first one is flex time or shifts. Here, what an employee does is as long as they get their work done during the day, it doesn't matter what time they work. They may work from 7 a.m. until 11 a.m. and then come back, do things personally, and then finish their work from, say, 4 p.m. until 8 p.m. Shifts is simply taking the traditional 9 to 5 and moving that to another block of work time that works not only for the employee, but for the organization. The compressed work week, this comes out of healthcare primarily, but we see 4 10-hour days, 3 12-hour days, and then in the social services world, what we're seeing are 24-hour shifts or variation thereof. Telecommuting, we have all become very familiar with, and quite frankly, as long as you have the technology support behind you, it becomes much easier to do. The one, though, that's getting a lot of press right now is the hybrid telecommuting and hoteling concept. And telecommuting, again, you're working remotely, doesn't matter from where, but hoteling, if I want to come into the office on Tuesday and Thursday, I call up a person at the office and say, could you please reserve a desk for me at the firm? I get to pick what desk if it's available. There's another concept called hot desking. I come in on Tuesday, I don't have a reservation for a particular desk, so I get whatever desk is given to me. And the 5th one is job sharing. And here we've got one full-time job, but it is completed by 2 part-time people. So those are the 5 big areas that we're looking at in terms of working remotely. So the benefits, well, recruitment and retention, number 1. Right now, our recruitment pool in general is about a 50-mile radius from where the organization is. When you allow remote work opportunities, Suddenly that 50-mile radius is blasted apart, and pretty much you have the entire world as a sourcing base. Because again, as long as someone is able to connect into the organization and complete the work that's needed, it doesn't matter where they're located. Retention, AstraZeneca, a pharmaceutical company, did a survey of their employees because they have phenomenal retention rates. 93% of their employees said the reason they stayed was because they were allowed the opportunity to work remotely. And this goes right to the next one, which is employee morale. Folks feel very strongly that when they're allowed to work remotely, it's an indication their employer trusts them. And it's also a sign that the employer is supportive of the fact that they need to have work-life balance. We'll talk about that more in a minute. With regard to attendance and absenteeism, people are much more likely to remain at work because they don't have to take time off during the day to complete other areas of their lives that are occurring at the same time work is. Absenteeism, I may not feel completely up and ready to go to work commute-wise, but I can still work at home. Therefore, the absenteeism decreases. Issues during emergency situations, can we all say pandemic? Productivity. When someone is working at home, the statistics are showing us that their productivity actually goes up. They have less distractions. Work-life balance, I mentioned this before, when we're able to balance both, we're going to be more productive and, quite frankly, more loyal employees. I'm going to go to wellness and decreased health costs next, though. The University of Minnesota did a study where they took a look at insurance costs with regard to people who are working remotely. What they found was they had happier employees, engaged in work-life balance, therefore they were feeling better and health costs decreased. This is an ongoing study, by the way. And finally, environmentally friendly. We're not using as much fossil fuels. Our roads are not being torn up as much. We don't need as large of an office space to operate out of. Therefore, we're having a reduction in heating, ventilation, and air conditioning. Okay, John, the next one. Get to that one. So key considerations. When you take a look at this, please recognize right now working remotely is a hot topic. It has to be. However, one of the things you want to do is to sit down with your management team as well as the employees affected and assess whether the job is suited for flexibility. In some cases, it may not. But again, make it a team opportunity to take a look at it. Set performance goals. What gets measured is what is set out in terms of performance goals. And maintain ongoing communication, because what may work today in terms of remote work may not work tomorrow, and vice versa. Also, too, use communication as not a gotcha, I'm checking to see if you're really working, but instead, a help you. What can I do to help you do even better? And that brings in the whole concept of ongoing feedback and looking at when do we work remotely, where do we work remotely, and how do we do it? What support systems are needed? And last slide, John. With this one, again, I've mentioned it, I take it from a team perspective. Sit down with the manager and the employees to look, what worked well? What challenges did we encounter? And can those challenges be overcome? And again, what's worth maintaining and what's worth exploring? Thanks so much, John.
Great, April, thank you very much. And for those of you who have not met April, April is our labor relations consultant. So we have, I see from the questions, it looks like we've answered quite a few of the questions. Is there another question that someone wants to bring up? Amy, do you see one?
Yep.
Yeah, go ahead, Amy.
A good question we had come in says, how should employees traveling to office from residents in another state be treated? Does this trigger the quarantine environment?
All right, good question. Who wants to take that one?
I'd be happy to jump in on that, John, because I mentioned the out-of-state quarantine. Our reading of the guidance is that if an employee regularly works in Vermont, say you live over in New York, you live in New Hampshire, but you regularly come into Vermont to work, that you're not considered to be an out-of-state worker for the purposes of the 14-day quarantine. However, if you live in another state, do not regularly work in Vermont, but are expected to come into Vermont for business outside in the normal course of things, that's where the 14-day quarantine would come into effect, unless you are an essential worker, right? So if you are a healthcare worker, as an example, who's hired to come into the state to take up an emergent need, that individual would not be subject to the 14-day quarantine.
All right, that's great, Ben. Thank you very much. And I guess we are at our time. We will have this session has been recorded, so you'll be able to see it on the Lake Champlain Regional Chamber of Commerce website. Kathy, are there any further comments you'd like to make? Before you do, I want to thank the Chamber again, and we really appreciate you having us, and we hope that this has been a useful service for your members.
Thank you very much, all of you. That was great. To the attendees, we will send the recording to everybody by email as soon as we receive it. Expect that in the next day or two. And please feel free to contact us if you have additional questions. We're happy to try to get those answered. But thank you to the DRM team. This was fantastic.
All right, great. Well, everyone, have a happy day and enjoy the sunshine. Bye, everybody.
Bye, everyone.
Bye now.